Hi everybody, today is November 9th, 2013. Malik Obama, brother of Barack Obama, may qualify as enemy combatant. The case of Salman Ahmad Hamdan, Osama bin Laden's one-time driver and bodyguard, and David Hicks, an Australian who trained in Afghanistan, may lay the groundwork for Malik Obama, Barack Obama's half-brother, qualifying as an enemy combatant. The president's older brother is the executive secretary of the Islamic Dawah Organization, IDO, which is run by a country designated as a state sponsor of terrorism, and a president who is wanted for crimes against humanity by the International Criminal Court. Malik Obama's attendance at the 2010 IDO conference in Khartoum is not just significant in itself, but could provide a legal basis for his providing material support for terrorism because of when that conference took place. A key to any charges against Malik Obama may involve the Military Commission Act (MCA) of 2006. When considering the fates of Hamdan and Hicks, both convicted of providing material support for terrorism, the year of this law's enactment is indeed significant. Hamdan's conviction was overturned because his crimes took place before the law was in existence. This from the New York Times. A federal appeals court on Friday overturned the terrorism conviction of Salman Ahmad Hamdan, a former driver and bodyguard for Osama bin Laden, whose case has been the most tangled to emerge from the war crimes trials of detainees held by the military at Guantanamo Bay, Cuba. The court found that Mr. Hamdan's conviction by a military commission for providing military support for terrorism could not stand because under the international law of war in effect at the time of his actions, there was no such defined war crime. The Military Commission Act, a law passed in 2006, does not authorize such retroactive prosecutions. A three-judge panel of the United States Court of Appeals for the District of Columbia Court ruled. Taken in 2010, photos demonstrate that Malik Obama, who is both a Kenyan citizen and a U.S. resident, provided and may continue to provide material support for terrorism 4 years after the law was enacted. Should, in consorting with a man wanted for crimes against humanity and who leads a country that is considered a state sponsor of terrorism, qualify? David Hicks, known as Aussie Taliban, is a man who was held at Guantanamo Bay for 5 years after being captured in Afghanistan. In 2011, he was convicted of providing material support for terrorism after pleading guilty. His lawyers are appealing the conviction based on the ruling in Hamdan. And this from ABC's. The basis for the appeal is a U.S. court ruling that the charge against him is invalid. In 2012, a U.S. appeals court in Washington ruled in the case of another Guantanamo convict, Osama bin Laden's one-time driver and bodyguard, Salman Hamdan, that providing material support for terrorism was not recognized as a war crime during the time Mr. Hamdan and Mr. Hicks were in Afghanistan. They were prosecuted under U.S. law enacted in 2006, and the court said it could not be applied retroactively. The ruling overturned Mr. Hamdan's conviction. So, Mr. Hamdan's ruling was overturned not because he didn't do what he was convicted of doing, but because he did it before the law making it a crime was enacted. Hicks' attorneys are making the same argument against his appeal. It is an argument that Malik Obama cannot make. He was providing material support to terrorism as recently as 2010 as Executive Secretary of the IDO. Let's take a look at how the law does describe unlawful enemy combatant. A person who has engaged in hostilities or who has purposely and materially supported hostilities against the United States or its co-belligerents, who is not a lawful enemy combatant, including a person who is part of the Taliban, Al-Qaeda, or associated forces, or a person who, before, on, or after the date of the enactment of the Military Commission Act of 2006 has been determined to be an unlawful enemy combatant by the Combatant Status Review Tribunal or another competent tribunal established under the authority of the President or the Secretary of State. As an Executive Secretary of an organization under the authority of the Government of Sudan, there is more than sufficient probable cause to suggest that Malik Obama has purposely and materially supported hostilities against the United States. At least one problem arises in the form of a familiar conflict of interest. In particular, Malik's brother, who happens to also be the President of the United States, is incapable of being objective in this case and should, recuse himself. The only other person with the ability to establish a tribunal to investigate Malik Obama is Secretary of Defense Chuck Hagel, who should either reconcile a conflict of interest as well. His boss's conflict should render Hagel incapable of doing his job in this case. It would certainly be grounds for Barack recusing himself, and unless Hagel can demonstrate loyalty to his boss, wouldn't interfere with his decision to form a military commission, justice may require his recusal as well. To illustrate this conflict of interest, consider that under 950I Executive of Sentence, procedures for execution of sentence of death. Execution of sentence of death only upon approval by the President, if the sentence of a military commission under this chapter extends to death. That part of the sentence providing for death may not be executed until approved by the President. In such a case, the President may commit, remit, or suspend the sentence, or any part thereof, as he sees fit. Even if Malik were tried and convicted under the MCA, the responsibility to carry out the sentence would fall to his younger brother. To include the death penalty, putting President Obama in this position, would not be fair to a legitimate system of justice. While actually trying Malik under the MCA could be far more difficult than convicting him under it. Take a look at what qualifies as principals under 950Q. Any person is punishable as a principal under this chapter who 1. Commits an offense punishable by this chapter, or aids, abets, counsels, commands, or procures his commission. 2. Causes an act to be done which, if directly performed by him, would be punishable by this chapter. Or 3. Is a superior commander who, with regard to acts punishable under this chapter, knew, had reason to know, or should have known that a subordinate was about to commit such acts or had done so, and who failed to take the necessary and reasonable measures to prevent such acts or to punish the perpetrators thereof. As the executive secretary of the ideal, Malik Obama must have known about subordinates are doing, and his boss, Surur al-Dabab, has consorted with both the Prime Minister of Hamas and Yusuf al-Qadari, the spiritual leader of the Muslim Brotherhood, the umbrella group for al-Qaeda. Page 77 of the Act, on line 1025, states the following. 25. Providing material support for terrorism. A. Offense. Any person subject to this chapter who provides material support or resources, knowing or intending that they are to be used in preparation for or in carrying out an act of terrorism, as set forth in paragraph 24, or who intentionally provides material support or resources to an international terrorist organization engaged in hostilities against the United States, knowing that such organization has engaged or engages in terrorism, as to set forth, shall be punished as a military commission under this chapter may direct. As an executive secretary with the ideal, Malik Obama absolutely fits his profile, if for no other reason than his employer as a state sponsor of terrorism. By definition, dawah refers to spreading Islam through proselytizing. This requires money. The source of said monies would also be subject to prosecution under the MCA. While a potential unlawful enemy combatant who has purposely and materially supported hostilities against the United States, Malik Obama received special and illegal tax-exempt status from the Internal Revenue Service, IRS, for his organization, the Barack H. Obama Foundation, BHOF, in 2011. His application was processed in less than 1 month and tax-exempt status backed 38 months. The signature of the IRS employee who granted Malik his tax-exempt status is Lois Lerner. If Malik Obama's crimes as an enemy combatant are proven, it would implicate Lerner in similar crimes by aiding and abetting said enemy combatants by providing illegal funds. An investigation into who or what prompted Lerner to do this is indeed warranted. Any superior who instructed her to grant BHOF tax-exempt status would also be subject to prosecution. Since Barack essentially has sole authority or discretion to prosecute crimes under the MCA, it would be unlikely for him to recuse himself from the case. How may justice be served? The answer is through Congress and the Court of Public Opinion, CPO. One congressman, Representative Mike Kelly of Pennsylvania, who sits on the House Ways and Means Committee, has publicly stated that the aforementioned claims against Malik Obama and Lois Lerner are spot on. In order for this case to be introduced in the CPO, members of Congress must be speaking publicly about it. One or more must also open up an investigation into the charges in his or her capacity on their respective committees. Congress and Senate, they'll never do it. They're all in the pockets of Obama and the Illuminati, etc. And if they did and they didn't diddle-daddle about it, I bet you they would eventually find grounds for impeachment for Obama. Alright, bookmark my site. I'll keep you up to date. Please stay safe, and I'll talk to you later. God bless you. Bye.